Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Immigration sure appears to be heating up at the moment, no? When is it not? Leaving the Senate alone this week, Immigrants List reports that this week, the First Circuit revived a suit by Mexico that seeks to hold U.S. gun manufacturers responsible for thousands of weapons illegally trafficked south of the border. Reverse migration of guns. So I guess that lawsuit is alive and kicking in the First Circuit. Also this week, the Seventh Circuit held that the doctrine of consular non-reviewability prevented it from reviewing the Department of State's refusal of a visa to 4 Iranian citizens who have family in the United States on the grounds that they were barred under the INA's terrorism-related inadmissibility grounds due to their mandatory service in the Islamic Revolutionary Guard Corps many, many years ago. And that was despite the fact that it was mandatory service and well before the IRGC was designated a terrorist organization by the Trump administration. Honestly, I'd probably have reviewed this full decision, but as consular non-reviewability is before the Supreme Court this term in Munoz, I figured that soon, consular non-reviewability will likely be changing anyway. Be it harsher if not impossible to challenge, or such that the Seventh Circuit was wrong in this decision. Harsh ruling though, but then again, the doctrine of consular non-reviewability as created by the Supreme Court is a harsh thing. Here are your 6 cases for episode 197. Starting off, we have matter of Aguilar Hernandez, published by the BIA. Starting off with the BIA, you know what that means. This case is about deficient NTAs. And while I was not the attorney on it, I must note that it confirms a footnote that I've been dropping in my own motions to terminate on this matter since matter of Hernandez. Something I can unabashedly say and which no one can fact-check me on except EOIR staff, who are sworn to secrecy in a very medieval ceremony that occurs on the first day with EOIR. Mr. Aguilar Hernandez, naturally, is a respondent in removal proceedings. DHS began those proceedings, however, by serving him with a notice to appear that did not have the date and time of his first removal hearing. The Immigration Court, which is not a component of DHS, followed up with a notice of hearing, containing information for Mr. Aguilar Hernandez's first hearing shortly thereafter. So, Mr. Aguilar Hernandez moved to terminate his removal proceedings at that first hearing, arguing that the NTA was legally defective because it did not contain the date and time of his initial removal hearing before the immigration judge in violation of INA Section 239A1GI. The IJ denied that motion in 2019. Thing is, it's totally right now. Under matter of Hernandez, timely assertion of this mandatory claims processing rule must be remedied. As such, and presumably well into these proceedings, Mr. Aguilar Hernandez renewed his motion in October 2022, after Hernandez and a lot of other precedent had been decided. The IJ denied that motion again, though, allowing DHS to instead, ostensibly, remedy and amend the deficient NTA by filing a Form I-261. But that doesn't make sense, does it? That's what my footnotes and surely many others have been arguing. Matter of Hernandez was vague about what's required to remedy a deficient NTA, but it doesn't make sense to amend an NTA with an I-261, right? And that's what this decision is all about. And that is what the BIA held here. On an almost never considered interlocutory appeal, by the way, meaning proceedings before the IJ haven't even concluded yet. Nice case law footnote on what's required to get the BIA to consider your interlocutory appeal, if you're interested in the future. To sound like a court, I assume listener familiarity with the issues presented. Suffice it to say that NTAs must have the date, time, and location of a non-citizen's first hearing, and if they don't, they violate a mandatory claims processing rule. In matter of Hernandez, the BIA said that upon timely objection to a deficient NTA, an IJ may terminate proceedings, but also, quote, should afford DHS an opportunity to remedy the defective notice to appear, end quote. A bit contradictory, to be honest with you. Neither I, the dissentient Hernandez, or anyone I spoke with after Hernandez understood what that meant, but perhaps understandably, the only thing DHS could think to do in lieu of simply moving to terminate deficient proceedings was to file a Form I-261. That's really the only tool DHS has to amend NTAs, and that's what it argued it could do here. But here's the problem. 8 CFR section 1003.30 authorizes DHS to submit I-261s in order to provide, quote, additional or substituted charges of deportability and or factual allegations, end quote. But that's not what's happening when an NTA is deficient as to a date, time, or location of the first hearing. Those aren't factual allegations or charges of removability. And they are core to the NTA itself. They aren't simply things contained in the NTA, they are the NTA. That's what INA Section 239A seems to imply. And that's what recent case law makes pretty clear. Or, as the BIA put it, quote, the plain text of 8 CFR Section 1003.30 does not support DHS's argument, end quote. Citing De Kaiser v. Wilkie from the Supreme Court, the BIA intelligently realizes how careful it must be to withstand circuit review on regulatory interpretation. Not only is the plain text of the reg for Form I-261s a big problem for DHS, there's another, quote, in Niz-Chavez, the Supreme Court emphasized the government's obligation to turn square corners. Just as we expect a respondent to comply with an immigration judge's scheduling order or to make an asylum claim on an asylum application, it is only reasonable to expect the government to utilize its official forms in the way the regulations authorizing the use of those forms prescribe. Permitting DHS to use a Form I-261 to amend the date and time of the defective notice to appear as an administrative convenience would not be faithful to our obligation to turn square corners, and we decline to do so in this case, end quote. Sorry for the long quote, but also I'd be lying if I didn't admit that Justice Gorsuch's dicta and rationale from Niz-Chavez hasn't made the whole deficient NTA litigation thing kind of fun over the last few years. Not only that explained the BIA, but Niz-Chavez made clear that Section 239A1 information must be contained in a, quote, single document, end quote, i.e., an NTA. Can't amend a deficient NTA with an I-261. Period. Even if, as is the case, Mr. Aguilar Hernandez may not have been prejudiced by DHS's failure here because he continues to accrue continuous physical presence for non-LPR cancellation of removal purposes, and he appeared for those hearings, matter of Hernandez makes clear that prejudice isn't required to succeed on motions such as this, and that in any event, quote, DHS confuses a remedy with a result, end quote. This is actually pretty interesting. The BIA explains that, quote, it is a strategic decision by a respondent to raise or not raise an objection to a defective notice to appear, lacking the date and time of the initial hearing before the immigration judge, end quote. And that's true, it is. And also, remember that counsels if you get hit with a Lozada complaint down the road for not raising a defective NTA issue. But if timely raised, DHS, or I guess the IJ, must remedy, even if the remedy might eventually result in a non-citizen's continuous physical presence clock stopping. Recall, the continuous physical presence issue is how all of this started in Pereira. I know, it's been a while, and we are so far past that even bringing it up seems surprising. Oh, how far we've come from the no harm, no foul line of cases published in the wake of Pereira. How is DHS to remedy all this? The PIA still doesn't say! Incredibly, really. But maybe it's because there's nothing more to say unless and until the regulations are amended? I struggle to see how termination isn't now required upon timely assertion of a non-Section 239A1 compliant NTA. But then again, the decision here doesn't come out and say it. All of that means, big congratulations to friend of the podcast, Bashir Ghazi Alam, who actually did oral argument on this at the BIA in Falls Church. Check out the special episode I did with Bashir way back when, on October 21st, 2021. Nothing to do with deficient NTAs, arguably a much more interesting interview. Also, and having been made aware by the BIA's footnote, condolences on the passing of appellate immigration judge Earl Wilson. And that is matter of Aguilar Hernandez. Alright. Next is Gaspar-Felipe v. Garland, published by the 8th Circuit on January 30th, 2024. This case is about asylum. Mr. Gaspar-Felipe is a, quote, indigenous Guatemalan citizen who came to the United States in 2013 to earn money to help his sick father pay down medical debt, end quote. That debt was incurred from a woman named Alponia Nicholas. When the father couldn't pay, he began receiving threats. Then, Mr. Gaspar-Felipe's uncle was killed. Mr. Gaspar-Felipe suspected it was Miss Nicholas's doing. Also, Mr. Gaspar-Felipe's brother had been beaten up 3 times. Although he didn't have hard proof that it was all Miss Nicholas's doing, it was the case that, quote, after police involvement, Miss Nicholas did make a financial contribution to Mr. Gaspar-Felipe's family to avoid legal problems for the uncle's killing, end quote. So that's not insignificant circumstantial evidence. Even after Mr. Gaspar-Felipe paid off the debt, Miss Nicholas demanded more money. But his father hasn't been threatened since, and it's been 11 years, really 16 years as of the time of this decision. And Mr. Gaspar-Felipe has never himself been harmed or mistreated in Guatemala, but he does fear the gangs that operate there. The immigration judge and the BIA denied asylum and related relief, as did the 8th Circuit. Now first, Mr. Gaspar-Felipe argued that the IJ didn't sufficiently consider his indigenous-based claims, and in this decision, the argument is the first time we're hearing about such claims. But in any event, the 8th Circuit disagreed. Although the IJ used somewhat sweeping language at the time, the 8th Circuit believed the issue properly considered. And regardless, quote, the IJ sua sponte engaged Mr. Gaspar-Felipe's counsel in a discussion about a potential ethnicity claim, end quote. The IJ did enough. And these 8th Circuit decisions are often pretty short. This one is no different. The court sweeps through some other challenges. For example, it doesn't believe any of this happened on account of a protected ground, as asylum requires, or that any fears in the future are well-founded given that many family members still live in Guatemala safely. Quote, the reasonableness of a fear of persecution is diminished when family members remain in the native country unharmed and the applicant himself has not been singled out for abuse, end quote. And so, the 8th Circuit denied Mr. Gaspar-Felipe's petition for review. Wish I had more to convey. And that is Gaspar-Felipe v. Garland. Two from the 8th this week. This is Davis v. Garland, published by the 8th on February 1st, 2024. This case is about asylum termination and motions to reopen. Mr. Davis is from Liberia and was admitted into the United States as an asylee from abroad in 2008. But he, quote, began using drugs and experiencing mental health symptoms, later diagnosed as depression, bipolar, schizophrenic, and post-traumatic stress disorder, end quote. And if I'm being honest, U.S. immigration law is not the best at dealing with people who suffer severe mental health issues and commit crimes as a result or in relation to those issues. By 2014, Mr. Davis was homeless and committing crimes, eventually resulting in a 58-month sentence for aggravated robbery and fleeing a police officer. USCIS accordingly notified Mr. Davis of its intent to terminate his asylum status. Not 100% of USCIS can actually do that, though, under these circumstances. Maybe they can, but here it all ended up in removal proceedings, where DHS urged an IJ to terminate Mr. Davis's asylum status based on his criminal conduct. Mr. Davis then conceded removability. Unsure what that means, as conveyed here, this procedural history is confusing, and then Mr. Davis sought a waiver of inadmissibility, which an IJ denied. On appeal to the BIA agreed that a waiver was not warranted, but remanded because, in fact, the IJ had not expressly first stated whether Mr. Davis's asylee status had been terminated in the first place, which would then, I guess, require a waiver. And I guess that explains a bit of my confusion with this procedural history. While on remand, Mr. Davis began to take his psychiatric medications, and told new counsel, perhaps for the first time, about his mental health struggles. Quote, these struggles included hearing voices, confusing reality with the imaginary, and failing to take the proceedings seriously. He described hardships in Liberia, where he had been beaten by military groups, interrogated about his tribal membership, sexually assaulted by an older man while living in a shelter for children, and subject to other violent experiences. End quote. And so on remand, new counsel sought to reopen the case. Again, a bit unclear what's really going on here, because we're back before the immigration judge anyway, right? But new counsel wanted to provide lots of testimony and explanation, and I guess for an asylum and admissibility waiver, reopening was required. But the IJ, not unreasonably, construed the BIA's remand as narrow, intended solely to determine whether Mr. Davis's asylum status had been terminated, and the IJ expressly did so this time, ordering Mr. Davis removed to Liberia. The BIA affirmed everything, cleaning up a bit what the IJ had found. The Eighth Circuit remanded. It saw this as a motion to reopen case. I guess the Eighth Circuit saw this as a matter where the waiver issue was indeed closed before the IJ on remand, and to hear new evidence on that waiver, the IJ needed to first reopen the entire matter. And to the Eighth Circuit, quote, the IJ's summary dismissal in one sentence of all of the non-citizens' arguments concerning the prior availability of the proffered evidence does not meet the requirements for adequately reasoned decision-making, end quote. Nor did the BIA actually engage with the facts of the case, stating simply that Mr. Davis had not, quote, established that evidence of his mental health issues and of his past and feared harm if returned to Liberia are new, previously unavailable, or would likely change the result in this case, end quote. Yes, that's the standard for motions to reopen, explained the Eighth Circuit, but the BIA doesn't explain why not, or engage with Mr. Davis's actual evidence. The Eighth Circuit wants more analysis. The court wants to know why, for example, the fact that the full extent of Mr. Davis's mental health issues becoming known on remand, notwithstanding some knowledge of their existence the first time around, doesn't warrant reopening and re-adjudication of his waiver claim. So the Eighth Circuit sent it back. And now that it's going back on remand counsel, might I quote from another mental health type case, Alcaraz-Rodriguez v. Garland, episode 192. After all, there, the Ninth Circuit explained that to deny a motion to reopen, quote, it is not sufficient that the evidence physically existed in the world at large. Rather, the evidence must have been reasonably available to the petitioner, end quote. And that is Davis v. Garland. Burned out with admin work? Most immigration lawyers are. That's why over 90 law firm owners have chosen Staffy to help them with the legal, administrative, marketing, and client-facing work. Staffy's goal is to help immigration lawyers live a more balanced life while seeing their law firms grow and scale. And they do that by providing a service that includes top-notch bilingual virtual staff with the HR support that will alleviate the law firm owner from onboarding, continuous management, and training of their virtual teams. Concentrate on this strategic work and let the team at Staffy help you with the rest. I have a Staffy and I couldn't be happier. Schedule a free initial consultation with Staffy at getstaffy.com and claim $500 off by using the code STAFFY2024. That's STAFI 2024. Moving on to Lopez-Benitez v. Garland, published by the Fourth Circuit on January 30th, 2024. This first case from the Fourth Circuit is about nexus. Indeed, this is a trio from the Fourth. The Fourth. Oh yeah. Let's see how that plays back on the edit, and we'll determine if we leave it in. Mr. Lopez-Benitez is from El Salvador and was placed in removal proceedings after establishing that his fear of return to El Salvador was credible. He explained to the asylum officer that while he had never been harmed by MS-13, they were always asking him for money, probably demanding it, to be honest. He complied out of fear because they told him if he didn't pay, they'd murder him. I must stop to note that, because of the Hincapi Zapata v. U.S. Attorney General decision out of the 11th Circuit from episode 25, and just generally because of how the BIA reads the inadmissibility provision, if this was the FARC doing this to Mr. Lopez-Benitez, and he lived in Florida, Georgia, or Alabama, not only might this not get him asylum, but it would likely be the material support of terrorism. That is, paying the FARC under duress. And isn't that just insane and arbitrary? Just thought I'd note. Anyway, this was El Salvador and it was MS-13. Mr. Lopez-Benitez didn't quite know why MS-13 was targeting him, and he told the asylum officer in the U.S. that they targeted a lot of people in town. But he suspected it was because they knew his parents were in the United States and so that he had money. In removal proceedings, he asserted that MS-13 had persecuted him and that it was on account of his membership in two particular social groups. First, the family of his father, and second, Salvadoran males without male protection. I guess he was young at the time. In removal proceedings, he expanded upon this testimony. He was a young man during all of this, and he still had uncles and a grandfather in El Salvador who were never extorted, it seems. The country condition reports he submitted emphasized that, among other things, quote, the gangs often threaten families to induce compliance with their demands, end quote. The IJ denied asylum and related relief. The IJ found the first particular social group cognizable, the family one, but the second one not, and that in any event, the IJ didn't believe that this was the reason for MS-13's extortion. The IJ also denied cat protection. The BIA affirmed, as did the Fourth Circuit, addressing only nexus and not some of the other issues raised. On that, and in the Fourth Circuit, and at least for asylum, quote, although an applicant need not show his protected status provides the central reason, or even a dominant central reason for his persecution, he must show that it is more than an incidental, tangential, superficial, or subordinate reason for his persecution, end quote. And it is also true that in the Fourth Circuit, the nexus focus requires an analysis of, quote, why the applicant was the target of the persecution and not some other person, end quote. A fairly favorable standard for non-citizens. But to the Fourth Circuit, Mr. Lopez-Benitez didn't actually provide evidence to show that he was targeted because of his family membership. Even his testimony, the only real evidence on the issue, was a bit vague. Quote, for example, Mr. Lopez did not testify that the gang members told him they were targeting him because of his father's presence in the United States, or that the gang's extortion attempts immediately followed Mr. Lopez's receipt of money, end quote. Plus, he didn't testify that other family members were targeted, something that undermines his family-based claim. As did the fact that MS-13 targets many people in the town. Although Mr. Lopez-Benitez was deemed credible, citing the Supreme Court in its recent Ming Dai decision, the Fourth Circuit reminds us that, quote, it's not always the case that credibility equals factual accuracy, nor does it guarantee a legal victory, end quote. As to Convention Against Torture Protection, which doesn't require a nexus to a protected ground, the Fourth Circuit believed that the BIA properly deemed the argument unexhausted. Mr. Lopez-Benitez's brief to the BIA, quote, only mentioned the cat in its introduction and statement of facts. It never laid out the legal requirements for the cat, nor did it challenge the immigration judge's determination that Mr. Lopez-Benitez didn't meet said requirements. So his brief didn't sufficiently raise the issue, end quote. The Fourth Circuit therefore affirmed the agency's denial. But I've got some more interesting things to discuss. First off, here, the Fourth Circuit refused to review Mr. Lopez-Benitez's argument that the IJ erred in finding that the second particular social group of Salvadoran males without male protection was not cognizable. And that was because Mr. Lopez-Benitez never made the argument to the BIA. To the Fourth Circuit, the Supreme Court's Santos-Zacaria and post-Santos-Zacaria precedent from the Fourth stands for the proposition that, quote, the requirement that a non-citizen seeking judicial review of a removal order first exhaust administrative remedies, while not jurisdictional, is nonetheless mandatory, end quote. That seems like an important, no-nuanced quote to be distinguished in the future for Fourth Circuit petitions for review, if possible. I mean, no exception? Mandatory? None? Never? On a bit more positive note for non-citizens, and for what it's worth, the BIA actually overturned part of the IJ's finding below. Quote, in the order, the immigration judge stated that extortion is not a recognized ground for asylum. But the BIA acknowledged extortion is a recognized ground for asylum, so long as it is sufficiently severe, end quote. And that's relying on Olivia v. Lynch, out of the Fourth Circuit in 2015, and it's an important thing to remember in the Fourth, and for BIA appeals everywhere, really. And that is Lopez-Benitez v. Garland. Moving on, we have Ayala-Osegueda v. Garland, published by the Fourth Circuit on February 1st, 2024. This case is about gang-based asylum claims and credibility. We have here Luis, Sandra, and their minor son. If I don't use first names here, it's going to get way too confused. The petitioners are a family of asylum seekers from El Salvador. They testify that in 2009, one of their relatives named Guadalupe dated a local MS-13 leader named Francisco. But when Luis's mother disapproved, Guadalupe broke it off and fled to the United States. MS-13 targeted the family in retaliation. So the testimony went. Sandra testified in court that Francisco had extorted the family through anonymous letters left under the door of their fast food business. Sandra said Francisco extorted other family members too, and said that the whole family would be killed if they returned to El Salvador. On cross-examination, though, Sandra conceded that neither Francisco nor his associates ever actually said that they sent the letters. Instead, the family just assumed it, as MS-13 was the only gang in town. More problematic, to me at least, and I must admit good cross-counsel, is that, quote, she also conceded that the letters were delivered only after they opened the fast food restaurant in April 2016, 7 years after Guadalupe's purported breakup with Francisco, end quote. Further problematic, apparently, the affidavits of support submitted by Sandra and Luis contradicted one another a bit, which leads me to again question this practice, sometimes required of IJs, of having testifying witnesses, especially respondents themselves who are definitely going to testify, submit written affidavits beforehand. And it seems like here that both actually said in their affidavits that no one knew what had happened to Guadalupe, and that everyone suspected MS-13 had taken her. But then both testified on the stand in court that Guadalupe actually lives in Virginia. So that's not great. In fairness to the petitioners, apparently they argued to the Fourth Circuit that the affidavits were, quote, unscrupulously prepared by petitioners' prior counsel and were immediately disclaimed by petitioners upon questioning during their testimony, end quote. but it's not a good look. Sandra also got the date of an attack on her family wrong by 1 month, at which point the IJ, quote, advised her not to look at the other witness, in this case for assurance. And you too, sir. I see you nodding back and forth to the respondent. That is disfavored by the court. You cannot communicate with the witness on the witness stand. It does affect the court's assessment of the credibility in this case. End quote. So things weren't going great. Luis testified after Sandra, and it looks like more consistently, and he testified that the attack occurred in October 2016, and that they threatened to kill him, his wife, and their son if they didn't pay. But Luis didn't know who the attackers were, and conceded on cross-examination that none of them mentioned Guadalupe. The IJ found Luis and Sandra not credible as to their testimony that their experiences in El Salvador were retaliation for the Guadalupe relationship. The IJ also noted the lack of corroboration, including from Guadalupe herself, who was apparently in Virginia. No medical evidence from the attack was submitted either. The IJ also found some of the asserted particular social groups not cognizable, and that there wasn't a nexus here to a family membership. On a well-founded fear in the future, and despite the partial adverse credibility finding, the IJ noted that Luis's mother and other family lived in El Salvador unharmed. Cat was denied too. For all intents and purposes, the BIA affirmed. As did the Fourth Circuit. The petitioners first challenged the adverse credibility finding. What must an IJ expressly say to deem a non-citizen not credible? If they say nothing on credibility, the non-citizen is deemed credible, we know that. And if they expressly make an adverse credibility finding, well, they're not. But what about the stuff in between? Well, an IJ need not use, quote, magic words when making an explicit adverse credibility finding, end quote. Rather, it's more about the substance what the IJ says and reasons. And here, the IJ said, quote, the court makes a mixed finding on credibility today, end quote. Crystal clear to the Fourth Circuit. And it was also clear that that mixed finding was the IJ not believing that the story of harm was in relation to the Guadalupe event. So that's where we're at. But is that even allowed? A mixed or partial credibility finding? It is. Nothing in the INA prevents an IJ from finding part of a respondent's story credible and another part not, explained the Fourth Circuit. And outside the immigration context, quote, in courtrooms across the country, triers of fact can and regularly do find parts of testimony credible and other parts incredible. Indeed, federal courts typically instruct juries that they may do just that, end quote. Take note, IJs are not required to, quote, declare all of the testimony incredible, even though only some of it was, or declare it all credible, even though some was not, end quote. Interesting beginning arguments for appeal, methinks. Anyway, all this is supported by the Supreme Court's recent Ming Dai decision, episode 58, whereby the Supreme Court said that an IJ, quote, is free to credit part of a witness's testimony without necessarily accepting all of it, end quote. The Fourth Circuit went on to explain that even when testimony is credible or presumed so, that's just a first step. Quote, just because testimony is presumed credible does not mean that the BIA must accept it as true or that an applicant will prevail on appeal, end quote. Still need to persuade the IJ and meet your burden of proof. Pesky Real ID Act. And so here, credibility aside, even if the petitioners believed they were targeted because of Guadalupe's relationship, it doesn't make it true or sufficiently persuasive. Seems like the Fourth Circuit is trying to make a point this week in tandem with the decision we just discussed. As to the IJ's finding that the other evidence not tethered to their credibility didn't show that the family relationship was one central reason for the harm they purportedly suffered, well, the record didn't compel reversal. Those extortion letters were ambiguous as to who was leaving them, and Luis himself testified that he thought he was attacked because he owned a restaurant. And it was all years after the infamous Guadalupe-Francisco breakup. Quote, the timing of threats can be relevant in determining a persecutor's motivation, end quote. Hurt the petitioners here, said the Fourth Circuit, and they did not succeed. But I got this thought. In this case, the Fourth Circuit jumped right into the law before discussing the facts or truly the issues. I've never seen it before, but it's not Iraq. I guess it's a REAC? That's barely a joke, I'm sorry. But one of the things the Fourth Circuit did say in that section was that, quote, an adverse credibility finding determination supported by substantial evidence generally dooms an asylum claim unless the applicant can prove actual past persecution through independent objective evidence, end quote. And while that is of course a very difficult standard to meet, it's not impossible. We know this to be true in the CAT context, that an adverse credibility finding doesn't necessarily tank a torture claim if independent evidence establishes the claim. But I personally have never seen it with asylum. Even though I guess I should have, because the Fourth Circuit is quoting its own precedent from 2022 for this proposition that I myself discussed on the podcast. But there you go. Here it is again. And to remember when your remand argument hangs on the thinnest of threads. Asylum and withholding of removal claims are potentially viable in the Fourth Circuit, notwithstanding an adverse credibility finding. And that is Ayala-Osegueda v. Garland. Concluding with Navarre-Santana v. Garland, published by the Fourth Circuit on February 2nd, 2024. Remember, a trio from the Fourth. This case is about false claims to U.S. citizenship, the deadliest of an immigration accusation. Ms. Navarre is from the Dominican Republic and she entered the United States on a visitor visa in 2000, seemingly with a young son. She overstayed. But then the son joined the U.S. military, served honorably, and was able to naturalize as a result. He then petitioned for his mother, Ms. Navarre, to get a green card, which she could do because she entered the U.S. with authorization all of those years ago. I feel like if she hadn't, parole in place might have been available for her, but I've never done a parole in place. Something to investigate if you ever get such a case. But anyway, USCIS denied the application. See, in 2013, she apparently signed a Form I-9 to work at an elder care facility, and she signed the form under the question saying that she was a U.S. citizen. Life is hard in the U.S. if you're here without authorization and you want to work. The false claim to citizenship inadmissibility provision is a permanent and generally unwaivable bar to adjusting to LPR status and will make a non-citizen removable. It is one of the harshest aspects of all of immigration law, for signing an I-9. Certainly removable, having overstayed her visitor visa, and now with an adjustment of status application denied, USCIS placed Ms. Navarre in removal proceedings. She asked for the IJ to approve her adjustment of status application, as was her right, and said through her attorney that she was, quote, eager to testify that she did not falsely claim to be a United States citizen on the employment eligibility form, and that someone else had improperly made that assertion therein, end quote. The IJ set a hearing for that and ordered that evidence be filed 15 days prior. Standard stuff. DHS didn't file anything. Standard stuff. Ms. Navarre filed a bunch of stuff, including an affidavit where she said she reviewed the I-9 and didn't recognize it, and never knowingly checked the U.S. citizenship box. Might win the day, as the BIA's matter of Richmond decision makes clear that false claim to citizenship inadmissibility must be based on acts that are actually made and with a subjective intent for a state or federal benefit. One of a few requirements. Thank you, matter of Richmond. Neither party actually submitted the employment eligibility form to the court, though. Seems like both Ms. Navarre and DHS might have thought it was already in the record. Ms. Navarre's counsel tried to show it to her on direct, to which the IJ said it wasn't in the record, and then to which DHS provided a copy for everyone, which then Ms. Navarre's counsel objected to, which is strange to me as relayed in this decision, but which the IJ admitted, thereby allowing Ms. Navarre's attorney to ask Ms. Navarre about it, as the attorney had wanted to do in the first place. Then, in a dagger to the heart that I never wish upon any litigator, quote, immediately after the employment eligibility form was accepted into evidence, Ms. Navarre's lawyer asked Ms. Navarre if she recognized it, and she responded, yes, I think I filled it out, end quote. Clients are the best. She then clarified that she only filled out the top part, and that she recognized her handwriting on that part, but she didn't remember checking the citizenship box. But get this. She brought an administrator from the elder care facility to testify, and that administrator testified that her handwriting, the administrator's, was on the form, as was a third individual. especially at the Social Security section of the I-9. Pretty important. This administrator didn't know who checked the citizenship box, though, but believed that the third individual probably did, because she had seen that third individual do it in the past. And perhaps most importantly, this witness testified that Miss Navarre, quote, never claimed to be an American citizen and had disclosed that she was not, end quote. Pretty good witness for a case like this. But then again, it looks like Miss Navarre submitted a letter from that third individual, in which that third individual says that she didn't check the citizenship box and blamed the administrator, who had just testified that she hadn't done it. So that's not the best, but this third individual also didn't believe that Miss Navarre had done it. The IJ nevertheless denied adjustment of status. The IJ believed that Miss Navarre bore the burden of establishing, quote, clearly and beyond doubt she was entitled to be admitted and is not inadmissible, end quote, and that she hadn't met it on this, quote, inconclusive, end quote, record. Ms. Navarre appealed to the BIA and argued before the BIA, as she had before the IJ, that the actual standard is simply that she establish her admissibility, quote, by a preponderance of the evidence, end quote, not clearly beyond doubt. Big difference. The BIA ultimately dismissed the appeal. The Fourth Circuit addressed the issues and affirmed the BIA. But like first, and this is just me, doesn't Patel divest the circuit of jurisdiction to entertain this whole case? Isn't this literally the Patel case? A dispute factually about what the adjustment of status applicant did in relation to a false claim to citizenship? I don't know. But also, I'm not complaining. Patel isn't even cited. Well, maybe it's because Miss Navarre really did bring solely legal challenges. But I don't know. Anyway, the first was that the IJ applied the wrong standard, that non-citizens need only establish their admissibility by a preponderance of the evidence to win an adjustment of status case. And that's always been my understanding, and it's what I always argue. After all, 8 CFR section 1240.8d, titled Relief from Removal, reads that non-citizens have the burden to establish eligibility for relief, and that if the evidence, quote, indicates that one or more grounds of mandatory denial of the application for relief may apply, the non-citizen shall have the burden of proving, by a preponderance of the evidence, that such grounds do not apply, end quote. So, that's directly on point. Well, explained the Fourth Circuit, the adjustment of status statute at INA section 245A2 provides that a non-citizen must prove that she is, quote, admissible to the United States, end quote. And then, relying on old BIA precedent, the Fourth Circuit states that the BIA has a, quote, long-standing and consistent practice of assimilating non-citizens applying for adjustment of status to the position of an applicant for admission, end quote. Meaning to the Fourth Circuit that adjustment of status applicants in the United States who have been admitted are actually like applicants for admission. Heck, read in concert with the Ninth Circuit's decision last week, everyone's an applicant for admission, no matter what the statute or the regulations say. It appears. Anyway, as you can guess, under an unrelated statute, applicants for admission must show that they are, quote, clearly and beyond doubt entitled to be admitted and are not inadmissible, end quote. You know, the applicants for admission historically outside the United States asking to come in. But that's what the standard the Fourth Circuit believes applies to Ms. Navarre here in her adjustment of status application in removal proceedings, again, relying on BIA precedent that seems to blatantly contradict the regulation. What then is the point of 8 CFR section 1240.8d? Also, much of the Fourth Circuit's reasoning here depends on deference to prior BIA decisions, which, if the Supreme Court vacates Chevron deference this term, will likely no longer be a thing. But according to the Fourth Circuit also, this kind of aligns with its prior precedent and that of the Sixth and Eighth Circuits. But see Romero v. Garland from the Ninth Circuit, episode 67. Here, it meant that the IJ and the BIA did not err. As to Ms. Navarre's argument that admission of the I-9 application in the first place was fundamentally unfair and violative of her due process rights, the Fourth Circuit rejected the argument. Ms. Navarre was made aware of the existence of this document and was shown it 2 years prior in her USCIS interview, apparently, and she said in her court affidavit that she had examined it. And it was her own attorney who had brought up the issue and sought to show her the form at the hearing, even if the copy ultimately came from DHS. Under these circumstances at least, and quote, although the DHS lawyer was untimely and should have complied with his duties, his conduct did not render the IJ hearing fundamentally unfair, end quote. Ms. Navarre therefore lost her case, and a harsh one for non-citizens everywhere. Again though, no preclusion of review under Patel. Before we depart for the week, here's the final, long footnote from the Fourth Circuit, apparently written by Judge King. Quote, although we are denying Ms. Navarre's petition for review, we do not make light of the misfortune of her situation. Ms. Navarre has resided in the United States without any apparent problem for more than 2 decades, nurturing and raising an apparently able and distinguished son who has served honorably in the United States Army. As an elderly veteran, I have a soft spot for soldiers and their families, and I deeply appreciate his voluntary military service for our country. Furthermore, Ms. Navarre, as an elder care service provider, has apparently worked diligently and performed important work in an understaffed and overworked profession. And Ms. Navarre not only performed important work, she was considered one of the facility's most outstanding caregivers, skilled and caring, always going above and beyond. Perhaps the situation deserves another look from the Department of Justice? End quote. And perhaps the false claim to citizenship bar, and at least when it has absolutely no connection to voting, is due a reasonable waiver from Congress. And that is Navarre-Santana v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.